So, good afternoon, everyone. Welcome once again to our virtual class. This is for Law on Obligations and Contract, REM 6201. So, I am Professor Maria Romana Daguio, your assigned online learning coordinator for this course. So, this week, class, we are going to discuss the first topic for contracts. So, we are halfway, class, now to finish the course. We're done discussing about obligations, and starting this week, we will be discussing about contracts. So this afternoon, we are going to discuss chapter 1 of that, which talks about the general provisions of contracts. So let us proceed, class. So here, Article 1305 gives the definition, class, no, of a contract. So what is a contract? So according to Article 1305, a contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So as you can remember, class, we discussed this briefly, no, during the obligations topic, that contract is considered to be a bilateral obligation, meaning the two parties, okay, excuse me, the two parties are bound to conform, no, to perform the prestation. So what are those prestations? It's either to give, to do, or not to do. Unlike in obligations, class, that only one party is bound to conform, that is the debtor. And the role of the creditor there is to demand from the debtor the prestation, no? The performance of the prestation. So here, meeting of minds, meaning, say, A and B, no, agreed on something. So, in-expect natin, class, na hindi lang si A ang susunod sa kung ano yung stipulations ng contract, but as well as B. So that's why this is a meeting of minds between two persons. So this article gives the definition of a contract. It lay emphasis on the meeting of the minds between two contracting parties, which takes place when an offer by one party is accepted by the other. So there is an offer and there is acceptance. So pag pumayag ka doon sa ino-offer sa'yo, then contract will commence, class. Doon magsisimula ang contract. So mapaperfect, no? Perfected ika nga ang magiging contract. So let us further distinguish, class, contract from that of obligation. So contract, as distinguished from obligation, is that contract is one of the sources of obligation. So again, if you can remember, okay, contract is just one of the sources of obligations, because we learned that aside from contract, obligations came rather from law, quasi-contracts, no, quasi-delicts, and acts or omissions punishable by law. Wherein, isa lang sa pinanggagalingan ng obligasyon ang contract. So, if you have now contract, then there is now obligation. So, sabi dito, there is no contract, no, if there is no obligation, which is true. Paano ka magkakaroon ng contract kung hindi obligado yung dalawang parties, no, to perform the prestation? So, on the other hand, obligation is the legal tie or relation itself that exists after a contract has been entered into. So pag nagkasundo na kayo, meron na kayong obligasyon sa isa't isa. Okay? Contractually related to one another. Ika nga. So here, there can be no contract if there is no obligation. But an obligation may exist without contract. Why is it so, class, that obligation may exist even without the contract? Because obligation may still exist, no, from law, from quasi-contract, as if there is a contract, quasi-delicts, obligation arising from negligence, and acts omissions punishable by law. So obligations arises from, or obligation arises from crimes committed. So pag may ginawa kang crime, obligado ka gawin ng isang bagay. So those are some other sources of obligation. So not necessarily mean, class, na lahat ng obligation ay galing sa contract, no? Because there are other sources of obligations. So let's have an illustration. So when Ben offers to sell his cake to Mona in the amount of 500 pesos and Mona agrees to the cost, there is perfected contract of sale. So there is an offer, no? Ino-offer yung cake for 500 pesos. Pumayag yung buyer, si Mona, na 500 ang halaga ng cake. Then there is now a perfected contract of sale between Ben, the offerer, and Mona, the offeree. So stages of making a contract. So we have 3. The first one is conception. So this is the stage where the parties begin their initial negotiation for the formation of the contract. So may pag-uusap na nagaganap, conception. Stage 2, we call that perfection or birth. So here, the parties had meeting of minds or mutually agreed to the object and consideration. Okay? So, before I forget class, in order for us to call it a valid contract, there must be 3 essential requisites. Merong kinakailangan ng isang contract para masabi na ito ay lehitimong contract, no? Una, consent, followed by object and consideration. So COC class, consent, object, consideration. So in other references class, excuse me, consideration is also called cost. But nevertheless, the acronym for that is COC. So essential requisites for contract is the COC. And ang sa obligation naman, if you can still remember, we have 4. The active subject, the creditor, passive subject, the debtor, the object, yung pinag-uusapan nila na prestation, and then the relationship, no? The juridical tie, no? Kung tawagin, vinculum juris. So we have 4 essential requisites for obligations, while in contracts we have 3. Again, that is consent, object, and cause or consideration. So here in second stage class, meron ng pagkasundo, meeting of minds sa kung ano yung object and consideration. So we call that perfection or birth. Perfected na. Pag sinabing perfected na yung contract class, meron na ngayon power ng batas, no? Force given by law. So third is consummation, no? Which consists in the performance of the obligation. So tataliman na yung parehong partido kung ano ang kanilang dapat gawin, no? Based on the stipulations in the contract. So the parties cease to be contractually related to one another. So bound na sila class, no? To conform to the contract, no? Sa prestation. So hindi lang iisa, dapat dalawa. So Article 1306, the contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. So, may mga contracts class na in order for that contract to be valid, they need to follow certain forms, certain aside sa forms, pati yung content, no, yung format, no, meron tayong ganyan. But in some other contracts class, you can modify your own, okay? You can include whatever stipulations you want to, no, for as long as you believe that this would be convenient, no, for the two of you, no, kay party A, kay party B. But there must be some considerations to that class. Hindi lahat pwede mo ilagay dyan. Dapat yung mga stipulations or clauses indicated in the contract, no, must not be contrary to law, morals, etc. So let's see the considerations, no. Speaking of that consideration, so we have 5. So contract must not be contrary to law. So a contract intended to circumvent and violate the law is void ab initio. So from the very beginning, when you say void, no, wala na, as if wala na nangyaring contract kasi nag-violate na nga siya doon sa law. So paano kayo nag-form ng contract if from the beginning class, alam nyo na meron kayo na violate na batas. Okay? So alam nyo na bawal magtinda ng ganito, no? Gumawa kayo ng kontrata between you and ikaw halimbawa si A. Tapos nakipag-deal ka kay B. Yung object ng contract nyo, halimbawa, unlawful, no? Illicit. So, hindi ito kakilalanin and wala itong force, no? Hindi siya magiging enforceable, no? So, next, contract must not be contrary to morals. So morals deal with norms of good and right conduct and evolve rather in a community. These norms may differ at different times and places and with each group of people. So kanya-kanya tayo ng paniniwala, class, ng kung ano ba yung mabuti, ano ba yung maganda. No? So ito na yung nag-evolve sa community natin na pinaniniwalaan natin to be good or right. So example, a contract to live together without the benefit of marriage is in consideration rather for a sum of money is considered to be immoral. So in other, say, religion or yung mga grupo, naniniwala sila na ang pagsasama ng out of wedlock ay immoral. No? Sa iba naman, accepted naman. Sa iba, okay lang, maraming asawa. No? So it depends on the morals that you believe, no? What you believe is good or right. Next, contract must not be contrary to good customs. So when you say customs, class, it consists of habits, practices which through a long usage have been followed and enforced by society or some part of it as binding rules of conduct. So dahil sa matagal na siyang pinapractice, sinusunod, naging basehan na siya, class, ng society kung ano yung tamang gawi, no? Right conduct. So it has the force of law when recognized and enforced by law. Example, a notarized legal separation agreement between husband and wife is contrary to good customs because we are expecting husband and wife to be together, no, despite of what they are into, no. So through thick and thin, sickness and in health, so on and so forth. So that would be against good customs pag meron kayong notarized legal separation agreement. So if you really want to have that, class, ang nasa batas natin is file muna kayo ng legal separation. So pag legal separation, hindi pa kayo pwedeng ikasal sa iba kasi hindi pa na-void yung contract nyo. Okay? Not until may decree na coming from the court na annulled na yung marriage ninyo, that's the only time, class, na pwede nyo nang gawin yung kahit ano. Kumbaga, annulment, ito yung pagbabalik lang sa kontrata doon sa pinakasimula na wala na kayong pananagutan pa, no? Dahil meron ng decree coming from the court na na-annulled na yung contract na yun. Kahit anong contract, kasi hindi lang naman marriage contract, no? Pwede nyo nang gawin, no? But not until, tandaan, not until na-annulled yun, ay enforceable, class, yung contract. Ibig sabihin, kung ano man yung stipulation nandun sa contract, ay kailangan nyo pa rin siyang sundin. Kagaya sa marriage contract, class, no? Hanggat hindi pa kayo annulled, still, no, valid yung contract na yun. So, hindi ka pwede ikasal sa iba kasi pwede kang kasuhan ng adultery, concubinage, no, kung ano man dyan, pwede kang kasuhan. So, not until, no, na-annulled yun, again, may visa. Not unlike void contract, class, from the very beginning, wala na. Yung marriage contract, class, kung may grounds ka na pwedeng ipa-cancel or ipa-annul yon, tawag natin doon is nagpo-fall siya sa voidable contract, no? Voidable contract, pwede mo siyang ipa-annul. So annulment, class, is a remedy, tawag natin remedy. Anong pwedeng gawin para maitama excuse me, yung contract? So annulment is a remedy. So next, contract must not be contrary to public order. The public order refers principally to public safety, although it has been considered to mean also the public well-being. Example, a contract legalizing adultery or concubinage. So next, contract must not be contrary to public policy. The public policy, class, as compared to public order is much broader, no? Since public policy may refer not only to public safety but also to considerations which are moved by the common good. So ano ba ang makakabuti para sa nakakarami? So example, a contract entered into by a prosecutor not to prosecute a carnapper in consideration for 1,000 pesos is against the public policy to punish crime. So what is expected from you as a prosecutor is to punish crimes, no? Hindi para pigilan, no, ang pagdinig o ang pagparusa sa mga taong gumagawa ng crime. So this would be against public policy. No contract shall be made, class, again, that is contrary to law, contrary to morals, contrary to good customs, to public order, and lastly, public policy. So those are the considerations class ng mga stipulations na stated doon sa ating contract. Careful lang, tama naman no, na pwede nyo namang isulat doon kung ano sa tingin nyo ang magiging convenient sa inyong dalawa provided that this stipulations are not contrary to law and yung kanina nabanggit natin. All right, moving on. Article 1309, the determination of the performance may be left to a third person whose decision shall not be binding until it has been made known to both contracting parties. Okay. So minsan class, pinapasa kamay natin ang mga bagay-bagay sa third person. Sila yung tao na hindi naman talaga bound doon sa contract. Halimbawa, ang kontrata ay between A and B lang. Pero may mga pagkakataon na kinakailangan natin ng service, no, or tulong ng third person. So, pwede nating ibigay sa kanila yon provided kung ano man yung tulong na yon, ano man yung participation nila na yon, hindi siya magiging binding class not until ipaalam niya yon doon sa dalawa, no, sa contracting parties. Example, Sandra sold her parcel of land to Brenda. It was agreed that Carla, a real estate appraiser, who happens to be the so-called third person here class, would be the one to determine the reasonable price of the land. So Carla then fixed the price after considering circumstances and factors affecting the value of the land. So meron ng na-appraise na halaga si Carla class. So dapat ipaalam niya ito kay Sandra and Brenda para maging binding. So in this case, Carla must make known her decision to Sandra and Brenda who would be bound the same. So that is Article 1309. So Article 1310. The determination shall not be obligatory if it is evidently inequitable. In such case, the court shall decide what is equitable under these circumstances. So, ano ba ang mas makakabuti? Ano ang patas, ano ang tama? Korte po ang magtatakda kung merong hindi pagkakaunawaan, no, dispute between two parties. So whatever be the determination made by the third person shall bind both parties except when it is evidently iniquitous, in which case, again, the court shall decide whatever is fair. So let's have an example to that. Juan, a tenant of a rice field of Mrs. De La Cruz, was not able to give the lease due to Mrs. De La Cruz for 2 consecutive rice season. So hindi nakapagbigay class ng upa sa sinasaka niya si Juan. Ang landowner ay si Mrs. De La Cruz. So 2 cropping season na siguro o anihan, hindi pa rin siya nakakapagbayad. Okay, who will decide on this class, on this case? How do you think it will be decided? Would that be based on justice or equity? So based on this article class, Article 1310, it says that the court will be the one or will only be the one, siya lang, no? Ang may karapatang mag-decide, no, on the basis of justice and equity. So if it is based class on justice, ang gagawin ni court class, ibibigay niya kung ano yung due, no, doon sa dalawa. Halimbawa, Juan, uutusan siya na magbigay ng kung anong tama according sa batas kay Mrs. De La Cruz. Si Mrs. De La Cruz, ganun din. She has the right to demand what is due to her. Okay? Pero, kung si korte, ibibase naman niya sa equity na tinatawag class, ang mangyayari dito, no, ere-relax ng korte yung sanctions ng batas. Meaning to say, hindi niya totally ipapataw kung ano nakasaad sa batas. No, ang gagawin niya, mag-apply siya ngayon ng humanitarian consideration. Kasi titingnan niya, equity nga, di ba? Titingnan niya, ano bang circumstances? Bakit hindi nakapagbayad si Juan kay Mrs. De La Cruz? So, say for example, that is because of some fortuitous events, no? Beyond control of Juan. Nagkaroon halimbawa ng natural disasters, no? Whatsoever na beyond the control of Juan, then bibigyan siya ni court ng humanitarian consideration. So again, class, only court will decide on that, not Mrs. De La Cruz or not Juan or kung sino mang third person, no? It's only the court. Next, Article 1311. Contracts may take effect only between the parties, their assigns and heirs, except in case where the rights and obligations arising from the contracts or contract are not transmissible by nature or by their nature or by stipulation or by provision of law. Okay, may mga kadalasan class by general rule no, napapamana no ng yumao ang rights and obligations niya sa kanyang tagapagmana no sa mga heirs niya. Okay? Pero may mga ilan class na sinasabi na hindi pwede, no? By their nature, hindi pwedeng ipasa. Either right man yun or obligation, hindi pwedeng ipasa sa tagapagmana. O kaya naman, duly stipulated sa contract na hindi ipapasa or clearly stated sa batas. To continue, the heir is not liable beyond the value of the property he received from the decedent. So, hindi ka mananagot, ikaw na nagmana class, hindi ka mananagot more than, higit doon sa minana mo. Halimbawa, sinisingil ka ng creditor nung yumaong nagpamana sa'yo ng 2M kasi yun ang utang ng yumao, 2M. Eh, ang halaga lang ng namana mo class is 1M. So, the creditor rather of the decedent will run after you just for the amount ng namana mo hanggang 1M lang. So, nothing more no, than 1M. Why? That is clearly stated in Article 1311. So, sa totoong buhay, may mga ganun na creditor na ikaw naman ang nagmana, ikaw ang tagapagmana. Okay? So, bayaran mo, ito ang utang. So, now you know, class, no? That you are only obliged no, to pay for the obligation up to the extent no, kung magkano yung minana mo. Hindi mo obligasyon na abonohan pa yung kulang. Kasi hanggang dun lang naman ang minana mo. So, parang lalabas nito, kung nagsobra yung utang doon sa minana mo, na offset lang din. Kunwari lang na may namana ka, pero itutulak mo rin yung sa utang, di ba? But, of course, no, hindi naman laging ganun ang case. Ito, sa cases lang na merong obligation. So, if a contract should contain some stipulation in favor of a third person, he may demand its fulfillment provided he communicated his acceptance to the obligor before its revocation. A mere incidental benefit or interest of a person is not sufficient. The contracting parties must have clearly and deliberately conferred a favor upon a third person. So let's read that in Tagalog class. Paragraph 1. Ang kontrata ay magkakabisa lamang sa pagitan ng mga partido, ang kanilang pinaglaanan at mga tagapagmana, maliban sa mga kaso kung saan ang mga karapatan at mga obligasyon na nagmumula sa kontrata ay hindi na ipapasa sa pamamagitan ng kanilang natural na katangian o sa pamamagitan ng pagkakasundo o sa pamamagitan ng pagkakaloob ng batas. Ang tagapagmana ay hindi mananagot ng higit pa sa halaga ng ari-arian na natanggap niya mula sa yumao. So malinaw class, ulitin ko, ang tagapagmana ay hindi mananagot ng higit pa sa halaga ng ari-arian na natanggap niya mula sa yumao. So yung example natin kanina, kung 1M lang ang minana mo, hanggang doon ka lang. Hindi pwedeng pati personal mong pera ay ibabayad mo dahil yun ang obligation ng yumao, no. Next, paragraph 2. Kung ang isang kontrata ay dapat na maglaman ng ilang kondisyon na pabor sa ibang tao, tawag natin doon third person, maaari niyang hilingin ang pagsasakatuparan kung siya ay nakipag-usap tungkol sa kanyang pagtanggap sa may pananagutan bago iyon bawiin, bago yun i-revoke. Ang kaugnay na benepisyo o interes ng isang tao ay hindi sapat. Ang mga nagkasundong partido, contracting parties, ay dapat maglinaw na sadyang ipinagkakaloob ang pagpabor sa ibang tao or third person. Heirs and assigns are liable for a contract entered into by the decedent because generally the rights and obligations are transmissible to them. Na ipamamana class, hindi lang yung rights, pati obligasyon. So what a person can receive by way of inheritance and therefore as an heir cannot be less than his legitimacy. So kailangan ma-receive niya kung anong dapat talaga para sa kanya, what is due for him or her. Neither can he be obliged to pay more on an inherited obligation than the estate that he inherited. Hindi siya pwedeng magbayad, maging obligado sa higit pa ng kanyang minana. Okay? So, general rule, Third person has no rights and obligations under a contract to which he is a stranger. Si A and B may contract. Si C, third person. Hindi naman siya kasama doon sa contract ni A and B, stranger siya doon. So, wala siyang rights and obligation under that contract. Okay? Kailan siya merong pakialam or kailan siya magiging involved no doon sa contract na stranger siya nung una. So, these are the instances, class. First, in contracts containing a stipulation in favor of a third person. So, kung clearly stipulated sa contract na meron doong participation si third person, so kahit yung contract na yun is between A and B, i-bound na rin, class, si third person because stipulated doon sa contract. Next, in contracts creating real rights. So, yung mga object minsan na nakapaloob doon sa contract ni A and B, suddenly, nasa possession na ni third person. So, now, third person is bound for that contract. Next, contract entered into to defraud creditors. Yung mga kontrata na pinasok para dayain yung mga nagpautang. No? So, the third person may involvement na rin doon. And lastly, in contracts which have been violated at the inducement of a third person. Ito yung mga nilabag na kontrata na merong ibang tao na nag-impluwensya sa'yo o sa kakontrata mo para hindi sundin kung ano yung nasa contract. Inducement of third person. So later, we'll have an example for each of that. Article 1312. In contracts creating real rights, third persons who come into possession of the object of the contract are bound thereby, subject to the provisions of the mortgage law and the land registration laws. So sabi natin kanina, as a general rule, third person class have nothing to do with contracts entered into by other persons. But the moment, no, it came to their possession, no, sa possession na ni third person, yung object ng contract ni A and B, so, bound na rin siya doon, class, no? Sa contract na yung kasama na siya doon, no? May pakialam na siya. Okay? So, Article 1312 of the New Civil Code speaks of third persons bound by contract creating real rights. So, sabi natin, as a general rule, again, third person have nothing to do with contracts entered into by other persons. However, third persons are bound by contracts creating real rights when the third person comes into possession of the object of the contract. So a real right is binding against the whole world and attaches to the property over which it is exercised wherever it goes. So let's have an example. Arturo leases his property to Ben. Okay? So ang lessor class si Arturo, ang lessee si Ben. Inupahan ni Ben yung property ni Arturo. Excuse me. So si Ben, ni-register niya, class yung lease contract. So later, no, after na ma-register, pero with consent ni Ben, benenta, class, ni Arturo yung property na yon kay Charlie. So Charlie here, class, is the third person na napasa kamay niya, nasa possession niya na yung object ng contract ni Arturo and Ben. Originally, class, no, as you can notice, wala naman sa eksena dito, no, si Charlie. Doon sa contract of lease ni Arturo and Ben. It's just between Arturo and Ben. Nagkaroon lang ng pakaialam si Charlie kasi because of real rights. Siya na ngayon ang may-ari nung property na yon, yung object ng contract ni Arturo and Ben. So Charlie, who was an outsider to the lease contract between Arturo and Ben, has become the buyer of the object of the contract of lease. Ano yung object na yon? Yung property, class. He must honor the lease contract between Arturo and Ben. So kahit na siya na yung bagong may-ari, class, kung ano man yung stipulation sa contract ni Arturo and Ben, no, yung contract of lease, halimbawa, as to the period na inuupahan ni Ben, as to the amount, magkano ang upa, no, as to the property na inuupahan, yung mga details ng contract, class, kailangan i-honor pa din ni Charlie yon. Okay, so that is Article 1312. Next, 1313. Creditors are protected in cases of contracts intended to defraud them. Ang mga nagpautang ay protektado sa mga kaso ng mga kontrata na naglalayong sila ay dayain. So, pinapanigan ng batas, no, ang creditor, ang mga nagpautang, doon sa mga kontrata na pinasok ng mga debtors, mga umutang, para yung kanilang inutangan ay dayain nila or takbuhan nila. In real life plus nangyayari yon. So ang iba ginagawa, kung may property siya, kasi sigurado yun ang isi-sheriff sa kanya, no? Yun ang aatakin sa kanya, ginagawa niya na kagad ng paraan. Binibigay niya sa ibang tao, pinapangalan niya, o kaya dinodonate naman niya. So, may habol doon class si creditor. So, pwede niyang iparescind. Ang tawag naman natin sa remedy na yun class ay rescission. No? Ipaparescind niya sa korte yung naging contract between ni debtor at nung third person. Ipapakancel niya para kung sakaling maibalik sa pangalan ni debtor yung property na yon, pwede na niyang habulin para masatisfy naman yung obligation ni debtor kay creditor. So, when a debtor intends to defraud his creditor and alienates his property without leaving enough for them, his creditor may file for rescission, as I've mentioned, of said contracts. So, kung lahat yon kinontrata niya, pinamigay niya sa ibang tao at wala man lang siyang iniwan para dun sa kanyang mga pinagkakautangan class, okay, pwede niya yon ipa-rescind. Sino ang magpapa-rescind class? Si creditor. So, magpa-file siya ng rescission sa korte and si korte ang mag-decide on that. So, this action of rescission of contract is also known as action Pauliana. So, pansin nyo, dalawa na yung na-mention natin na remedy sa contracts class. Yung una kanina, annulment. No? May na-found out ka na dahilan para ipa-void yung contract, file for annulment. Ito naman, rescission naman ang tawag, ipapa-cancel talaga yung naging contract. So, rescission ang tawag natin. So, right of defrauded creditors. This article represents another instance when an outsider can, in case, no, or can in a sense rather interfere with another's contract. Example, if Leia gratuitously gives Piolo a parcel of land, said creditors may ask for rescission of the contract to the extent that they have been prejudiced. So si Leia, okay, basta-basta na lang niya binigay yung lote niya o lupa kay Piolo, no? Wala lang, okay? So said creditors, kung sino man ang pinagkautangan ni Leia class, pwede niya iparescind yung contract between Leia and Piolo. Kasi obviously, ginawa lang ni Leia ang pagbibigay ng lupa na yon kay Piolo because gusto niyang takasan, gusto niyang i-defraud, no? Gusto niyang dayain ang kanyang creditors. Article 13.14, any third person who induces another to violate his contract shall be liable for damages to the other contracting party. Kung sino mang hindi partido sa kontrata ang manghihikayat na labagin ng partido sa kontrata ang laman ng kontrata, siya ay mananagot sa danyos sa naperwisyong tao na partido sa kontrata. Third person ka. Ibig sabihin, out ka naman talaga doon sa contract ni A and B. Ikaw si C. Pero, inimpluwensyahan mo si A na, oy, huwag mo nang sundin kung ano yung nakastipulate sa contract mo. No? Ganito na lang gawin mo, halimbawa. O sakaling, sumunod naman sa'yo yung isa sa contracting party na yon, parties na yon, si A. At merong natamong pinsala naman si B, no? Nakakontrata ni A. So, ang mananagot sa danyos class ay yung nag-impluensya, yung nag-induce, no? Si third person. Example, after agreeing to sell her parcel of land to Koke, Princess Sarah sells the land to Sedi instead because of the inducement of Heidi. May previous agreement na class si Princess Sarah na ibebenta niya ang kanyang lupa kay Koke. Kaya lang, etong si Heidi, inimpluwensyahan niya si Princess Sarah na kay Sedi mo na lang ibenta. Okay? So, ganun nga nangyari. Naibenta ang lupa instead kay Sedi and not to Koke. So, in this case, Koke can sue Heidi for damages. Pwedeng kasuhan ni Koke si Heidi ng damages. Halimbawa, class, kung lote yon, so nag-expect na yung tao na kanya na yun, mabibili na. Halimbawa, nakapamili na siya ng mga itatanim doon, no? Fertilizer, whatsoever. So, sayang lang din. Kasi hindi na pala magiging kanya yon. So, pwede niyang i-file as damages sa korte yon, no? Kasuhan niya si Heidi. However, The liability of Heidi for damages cannot be more than that of Princess Sarah for latter's violation of her contract. So, hindi po pwede na mas mataas pa, mas malaki pa ang babayaran ni Heidi, no, kaysa kay Princess Sarah. Kasi mananagot din dito klase Sarah. Naalala nyo, breach of contract ito. Okay? So, mananagot siya. Hindi po pwedeng ang sisingilin natin kay Heidi ay mas higit kay Princess Sarah because that would result, no, or pwede siyang ituring na unjust, hindi makatarungan. So at most, Heidi would be solidarily liable with Princess Sarah. So what would be the source of obligation of Heidi? So bakit nagkaroon ng obligasyon bigla si Heidi? Her liability class will be based on the theory of quasi-delict. So, di ba, nabanggit natin kanina, quasi-delict is one of the sources of obligation. So this is a perfect example bakit nagkaroon ng obligasyon bigla si Heidi because of quasi-delict. So the responsibility of two or more persons who are liable for quasi-delict is solidarity. Next, Article 13.15. Contracts are perfected by mere consent. And from that moment, the parties are bound not only to fulfill the prestation expressly stipulated, but also to all the consequences which, according to their nature, may be in keeping with good faith, usage, and law. So, pag na-perfect na class yung contract, perfected na, ibig sabihin, may force na ng batas, may consent, may acceptance, okay? So, hindi lang kayo inaasahan na tumalima kung ano nakasaad doon. Pero kung ano man yung magiging, or ano man rather yung nakapaloob na consequences doon sa contract, kayo din ang mananagot doon. Magso-shoulder, ika nga. Halimbawa, keeping with good faith. So, kailangan, ina-expect ng batas na kayong parehong party A and B, lahat ng ginagawa nyo dapat ay leading doon sa ikakaganda, ikakabuti, okay ng kontrata ninyo. Okay? Hindi po pwede yung isa nandadaya na pala, so hindi ka na good faith, bad faith ka na. So classifications of contracts according to perfection. Kailan ba magkakaroon ng force of law? So una, tawag natin doon consensual contract. It came from the root word consent, no? Consensual. Or that which is perfected by mere consent of the parties. So pag may consent na parehong parties, then meron ng perfection of contract. So example, when Anne, who is the employer, hires Brian, the employee, as soon as both have agreed on the terms of employment, a contract commences. So kung nilatag ni Anne, siya yung employer, okay, Brian, ito yung araw ng pasok, ito yung oras ng pasok, ito ang duties and responsibilities mo, ito yung job description mo, ito yung sweldo mo, ito yung benefits mo, so on and so forth. So pag pumayag si Brian doon, meron ng meeting of minds, no, may consent na siya, then contract commences. So magsisimula na yung contract nila. So another classification class is real contract. So una, consensual. Ito, real contract. Or that which is perfected in addition to the above by the delivery of the thing subject matter of the contract. So, aside from the consent of both parties class, may add-on dito. May kailangan pa. Ano yon? Delivery of the thing subject matter of the contract. Kailangan ma-deliver muna bago turing na perfected yung contract. Halimbawa, Zian borrowed from Yani 5,000 pesos. As Zian security for the debt, Zian promised to pledge his diamond ring to Yani. Okay. Umutang si Zian kay Yani. No? So nakuha naman na niya yung 5,000 pero pinangako niya, pinledge niya class, yung kanyang diamond ring para security, parang collateral baga ng kanyang utang. So before the delivery of the ring to Yani, the contract of pledge is not yet perfected because hindi pa nga delivered. So hindi perfected. So ito yung sinasabi dito sa real contract. So aside from meron silang consent, kailangan ma-deliver muna. So if Zian later on refuses to pledge the ring, Yani can demand the payment of the obligation although it is with a period. So anytime, pag hindi tinuloy ni Zian class yung kanyang security of debt, no, for debt rather, ay pwede nang i-demand ni Yani ang kabayaran ng 5,000 pesos na yon. So, but Yani cannot require Zian to deliver the ring as security because there is no real contract of pledge yet. There is a merely consensual contract to constitute a pledge. What exists is a personal right. So what is that right? This is the right of action on the part of Yani to demand the constitution of the pledge. Pwede pa rin pilitin. Ang meron lang karapatan dito si Yani ay pwede pa rin niyang pilitin si Zia na i-deliver yung ring. Pero hindi ito mangangahulugan na tawag dito na may pledge of contract of pledge kasi wala pang delivery. Okay? So tandaan lang class na ang real contract, no? Ano ang pinagkaiba niya kay consensual? Ito, may delivery of the object. No? Hanggat hindi na di-deliver yon, hindi perfected. Samantalang kay consensual, basta pumayag na yung dalawang party, meron ng perfected contract. Okay? So, moving on, Article 1316. Real contracts such as deposit, pledge, and comodatum are not perfected until the delivery of the object of the obligation. So, same thing with real contracts class, no? So, this article makes a distinction between a contract that is perfected by consent. We call that consensual or ordinary contract. While a real contract are those contracts that cannot be perfected without the delivery, such as comodatum, pledge, or loan. Okay, and loan rather. So comodatum class refers to gratuitous loan of a movable property which is to be returned undamaged to the lender. So ang pinag-uusapan dito class ay yung mga movable property, mga equipment, no? Tapos ibabalik mo na undamaged, no? Hindi sira doon sa nagpahiram sa'yo. We call that comodatum. So, walang real contracts class hanggat hindi na di-deliver yung movable property na yon. Next is pledge, no? Nabanggit natin to kanina sa case ni Yani and ni Zian. So, pledge is a bailment that conveys possessory title to property owned by the debtor to a creditor to secure repayment of some debts. So, kumbaga class, pansamantalang maibibigay ang title, possessory title doon kay creditor kasi ito ay naging security ng utang ni debtor sa kanya. Okay, we call that pledge. Next, illustration. When one enters into a contract of pledge, the contract is not perfected until the object pledge, no, has been delivered to the creditor. So suppose Mr. Louillier wants to convert his 24-karat ring to money because he is in dire financial constraints and he needs cash. Thereafter, he approached Mrs. Tambunting, the cashier of ZYZ Pawn Shop. In order to constitute a contract of pledge, no, the ring must be placed in the possession of Mrs. Tambunting. So, hindi naman po pwedeng mag-appraise class si Mrs. Tambunting kung magkano ang magiging katumbas na pera ng 24-karat ring na yon kung wala sa possession niya yung singsing. So in real contracts, delivery of the object is necessary because without the object, the other party, who happens to be Mrs. Tambunting, cannot exercise her duties under the contract. Okay. Article 1317. No one may contract in the name of another without being authorized by the latter, or unless he has by law a right to represent him. I repeat, no one may contract in the name of another without being authorized by the latter or unless he has by law a right to represent him. Walang sino man ang may karapatang gamitin ang pangalan ng iba, ikontrata ito sa iba, no? Pwera na lang kung merong authorization, no, coming from that person, no, or naka-stipulate sa batas na meron kang karapatan para gawin nun. So, a contract entered into in the name of another by one who has no authority or legal representation or has acted beyond his powers shall be unenforceable unless it is ratified expressly or impliedly by the person on whose behalf it has been executed before it is revoked by another contracting party. So, kung halimbawa, ginamit yung pangalan mo sa kontrata, no, ng ibang tao na wala ka naman wala ka naman authority na binigay sa tao na yon. So yung contract na pinasok niya, tawag natin doon, unenforceable contract. So pwede lang maging okay yun, class, kung meron na naman tayong remedy. So pangatlong remedy na to, class, sa discussion natin. Una, annulment. Second, rescission. Ito naman, sunod na remedy, class, ratification. Yun yung tawag natin. Ang ratification, class, ano lang to, approval lang nung taong in-involve mo, ang pangalan, na parang ina-acknowledge na rin yung kontrata na pinasok mo. Kumbaga, umokay na rin siya. No? In layman's terms, sige, okay na, pumapayag na ako. So, una, unenforceable. So, tinama natin, remedy na ginawa natin, ratification. So, it can be expressly or impliedly. So, pag sinabing expressly, tahasan mong sinabi. Pag implied, parang may, I can't think of the exact word, class, in Tagalog. Pag implied, parang yung actions niya, somehow magpapakita na umokay na siya. Hindi man niya tahasang sinabi, pero yung actions niya, yun yung magsasabi. So we call that impliedly. So requisites for a person, pahiwatig yon. I got the word, class. May pahiwatig, no? So requisites for a person to contract in the name of another. So kailan lang meron kang karapatan na gamitin ang pangalan ng iba? Una, if you are duly authorized, di ba? It can also be expressly or impliedly. Next, he must have by law a right to represent him. Kaya ka makikipagkontrata sa pangalan ng tao na yon kasi ikaw yung guardian, ikaw yung administrator ng property, halimbawa. So that ito yung sinasabi dito kanina, unless he has by law a right to represent. Ang pagiging guardian kasi, class, saka administrator, yan ay duly acknowledged dapat ng korte. Kaya hindi ka po pwedeng, I am the guardian of ganito. Lalo yun sa mga nag-o-own ng property below 18 years old, mga minor. So, kailangan mag-assign. Tawag natin doon, assignment of guardian. So, yun, class, ay acknowledge ng korte. No? Hindi lang, ako, ina-appoint ko ang sarili ko, maging guardian na ganito. No, hindi ganun kadali yun. No? Kailangan acknowledge siya ng korte. So, the contract must be subsequently ratified. Tinama, no? Ginawa ng remedyo. It can also be expressly or implied. This later we'll have an example to that. No? The case of Marga, Cassie, and Hector. So, ratification, no? Let's have further discussion on that. So, ratification is a principal's approval of an act of its agent that lack authority, the authority to bind the principal legally. Approval lang, umokay na siya. Okay, doon sa ginawa ng agent na yon na dinama yung pangalan niya, so later on, tinama, no? Kinlens yung contract, no? Nilinis. So the term ratification describes the act of making something officially valid by signing it or otherwise giving it formal consent. For example, ratification occurs when parties sign a contract. The signing of the contract makes it official and it can then be enforced by law should the need arise. So ito yung tawag nating, class, na remedy ay ratification. So here goes the example, class. In Marga's name, but without her authorization, Cassie sold Marga's car to Hector. So the sale of car, class, is considered unauthorized. So note, class, that in the example given, mere lapse of time cannot cure the defect. This is not the ratification required by law. Hindi dahil sa paglipas ng panahon, may tatama na kung anong ginawa nila dito sa contract. No, hindi yun ang nire-require natin na klase ng ratification. So, what would be the effect, class, nung pinasok na contract ni Cassie and Hector without Marga's consent or authorization? Contract is unenforceable, no? When it is represented by a person who is not authorized or has no legal representation. Hindi ka naman guardian, hindi ka naman administrator ng tao. So, unenforceable contract. Yung naging contract between Cassie and Hector. Ano ang remedy? Ratification, either express or implied by the person on whose behalf it has been executed. Ang gagawa po nito ay si Marga. Approval ni Marga ang kailangan natin para magkaroon ng ratification. So, halimbawa, na-ratify na. What would be the effect of that? So, ratification cleanses the contract from all its defects from the moment the contract was entered into. So nililinis na yung contract. Walang authority si Cassie nung una, but dahil sinign na ni Marga, ni-ratify na, so umokay na yung contract. So ratification ang remedy. So, but do note class that there can be no more ratification if the contract has previously been revoked by the other contracting party. So wala na tayong itatama, wala na tayong i-approve, i-ratify kung yung contract between Cassie and Hector has been revoked, binawi na, no, by other contracting party. Halimbawa, si Hector, binawi na niya yung contract between them ni Cassie. So wala nang ma-ratify class. So, why are some contracts unenforceable? So, we have mentioned earlier, unenforceable contracts. So, here are the instances or reasons bakit nagiging unenforceable. So, first, unenforceable contract is a written or oral agreement that will not be enforced by courts. Contracts may be unenforceable because of their subject matter. No? Halimbawa, hindi lawful. Because one party to the agreement unfairly took advantage of the other party. Dinaya niya, no? Nag-take advantage siya dun sa kakontrata niya, and there is not enough proof of the agreement. Wala tayong patunay na talagang may consent, no? Doon sa isang party. So those are the instances when can we say that a contract is considered to be unenforceable. So that concludes our discussion this afternoon class. So not unless you have questions, let us now proceed to question and answer. All right, so thank you so much class for joining and attending today's virtual class. Hope to see you again next week. So I hope you learned something out of today's discussion, and let us continue our lesson with regards to contracts. Next week, we will be discussing the essential requisites of contracts. So with that, thank you and God bless everyone. Bye!